removed a Chief Justice before. And so for me, the issues that she's bringing up are interesting for our democracy, both in terms of constitutional and administrative law. And we have to at least acknowledge the utility of the process that we are going to. What she had shown is that she has decided not to walk away quietly. And that, for me, at least that's commendable, that a person who believes that their rights have been aggrieved would have a framework for where they are challenging that. Now, that said, I am hoping that the way in which we treat this, that we treat it with a lot more sober reflection than outright dismissiveness. That the issues she's going to be bringing up, that her colleagues in the judiciary are not only going to look at the executive posture and say that, well, the executive has already moved on with a new candidate, and for which reason we must ensure that that status quo remains. So she has to get a fair hearing, and I'm hoping that the judiciary is able to afford her that. Administratively, there are questions, for instance, about whether significant findings of fact that were made by the Command Committee can themselves be disturbed by another body, or whether or not that process cannot be challenged in some regard. That's something that will be interesting to find out. I am not certain, in terms of my understanding of how we have done these things previously, whether or not the going forward with the appointment of a new person and the process of vetting the person can be stopped. I say this because, first of all, the judiciary must continue to function. And if she is found to have been wrongly removed, there's nothing stopping us from bringing her back in terms of how our law functions. So the mere fact that somebody has been vetted or whatever is done, if a former Chief Justice has not been rightly removed, there's nothing which would say, well, there's a fait accompli, and for which reason we can't bring her back. So that's my thinking. And so I don't particularly understand that relief, but I still believe that some of the questions she's raising, I do hope that, when proved, or if proved, that I'll be interested to see what the court ultimately decides on this. Not only in terms of what is before the High Court, but also some of the issues before the Supreme Court that we are aware of. And we know.
You said you are not sure, but what are you thinking? That the Article 146 process, when it's complete, it is subject to a judicial review by a High Court?
So, in terms of administrative law, it's a quasi-judicial body or judicial body, as you think about it. Its decisions are consistently challengeable. Whether or not it followed proper procedure, whether in terms of administrative justice, it offered her the hearing that she deserved, the manner in which it was offered was consistent with law. These are all issues that are challengeable, okay? And in connection with that, she's entitled, for instance, and we have said this previously, she's entitled to the report, she's entitled to be able to assess the reasoning, she's entitled to be able to see the facts that were sifted to see whether or not those facts bear themselves out. All that process, I think, she's entitled to it. Myself, at this point, I think it's a bit premature even for me personally to be able to say that, all of the claims that she's raising are not valid. And even when some of their claims are valid, whether or not they would lead naturally to the invalidation of the work of the committee are also issues that, deserve question. But I think somehow she has not lost faith in the judiciary, and I think perhaps that if there's any value to commend here, that's it, I would say.
Interesting. But I've heard you, often refer to the very first time that Article 146 was used under this dispensation, the 1992 Constitution. And that was in respect of Dr. Jacob Emmanuel Opong, who was removed as a deputy chairperson of the National Commission for Civic Education on the 28th of August 1999. And when he decided to challenge it, he went straight to the Supreme Court and he lost.
Yeah.
Because I have heard you refer to it, what do you say?
Well,
which is the better forum?
So the funny thing about, that decision itself, I'm not even certain that the Supreme Court sufficiently understood the law. Because the Supreme Court had assumed that the Article 146 Committee is a commission of inquiry, and for which its reports must await a period, there must be a white paper, and then, you challenge it in the way in which a report of the commission of inquiry is done. But now we understand, we have better clarity.
Let's educate the people.
Yeah.
A commission of inquiry's report, when they do a finding and they finish, it becomes
it's like a judgment of the
High Court.
Yes.
And it's appealable to the Court of Appeal.
Absolutely.
Within 6 months.
Within 6 months.
Okay.
So yeah, so that's what the Constitution establishes for that framework. There's a real question as to whether or not the Article 146 committee is equivalent to a commission of inquiry. I don't necessarily hold that view, and I think that subsequent bodies haven't. In fact, Supreme Court decisions also suggest, like for instance, they don't have the power of contempt and things like that, suggesting that we are trying to create a distinction between the 146 committee and also commissions of inquiry. So that route necessarily would not be the most appropriate route. So even though there's a Supreme Court decision on it, I think that, if you go back and review it, that will have a different opinion on it. So I think the appropriate forum in this case is the High Court, I believe.
Okay.
Because the High Court, and they're invoking the High Court supervisory jurisdiction.
All right.
So I think that's fair in terms of where they've gone.
Okay. Before I come to Prof, let me go to